The reality is that perhaps this person is actually much younger, and because the symptoms do happen progressively, you could start off with a symptom that you may not at the moment know or understand is attached to a dementia diagnosis, but if given a little further medical examination, would lead you to that understanding that that person at that moment isn't actually sort of responding in a way that is cognizant to them. But I can't speak to the other mental health conditions, but I do appreciate your point.
Further questions? All right, no further questions for this witness. Thank you so much for your testimony and waiting. Yes.
Thank you.
All right, any further public comment on this bill? All right, seeing no further public comment, no one is online. Public comment on this bill is closed. Committee, back to you. Representative Oakley, comment?
Thank you, Madam Chair. Just briefly from the last presenter, I guess two things I would say. One, intent can be negated by intoxication. Some things like there is that as a possible defense. But specifically what she talked about, I would think that there would be the NGMI, not guilty by reason of mental illness or deficiency, whereby if you are found that you do not have the capability to appreciate the criminality or the wrongfulness of your conduct, and then there's a whole process for that. But if there is something that exists in the law as a plea because of mental illness or deficiency.
All right, thank you, Representative Oakley. Committee, is there a motion on the bill?
Bill, Madam Chairman.
Moved by Zwanitzer, seconded by Senator Cost. A discussion on the bill, Representative Zwanitzer.
Thank you, Madam Chairman. Looking up, 32 states do have a felony provision for assault on healthcare workers. 6 have an enhanced penalty. As you heard, we seem to be the only state that doesn't have any type of, let's say, enhancement or acknowledgement of violence toward people in the healthcare industry. So whether that's EMTs or paramedics or doctors. And so I know many of us on this committee, because we're judiciary, keep talking about crime and punishment and intent. But I do think there's an element when we, regardless of the issue, when we're one of the only states that has nothing in this area, it turns into a much more of a competition in a restricted environment. To how do we make sure we get the right people here? And I do think having some type of provision, whether it's a felony or an enhanced penalty, something on our books, so when nurses, especially traveling nurses, because we can't find enough nurses in Wyoming right now, they're looking at states to attend, and they say, hey, Wyoming's the only state, we're always that big empty black box that doesn't have any law in this area. Maybe I don't want to go there if I can't, feel safe. And so I would ask the committee to push the bill forward. I know some people want it stronger and make felony provisions. I do think some enhancement is appropriate, necessary. We didn't hear from the EMTs today. I know a lot of those people are driving ambulances, being the first people on the scene. This is also a significant concern for them and their jobs as well. So,
Thank you, Representative Zwanitzer. Further discussion, Senator Cost.
Thank you, Madam Chair. When we talk about services and the importance of them, we look at the police, we look at the fire, we also look at our first responders and the hospital as being extremely important for our communities and all. And I think it's important that we step up and do the right thing for the nurses and the people that are in the industry, because they're trying to take care of people. They're not looking for violence. They're not expecting that. It totally is a different world for them to associate to, because that's not what their world is built around. I think that's very much something we have to look at. And I do agree that the black hole over there doesn't look good. And I do agree that traveling nurses and that become more aware of that. But I think the important thing is we need to do this for these people because it's the right thing to do. We need to make sure we're protecting them. I understand Alzheimer patients and all of that, and we've got to make sure that we help them because they do get violent, they do end up in circumstances, but I think that can be taken care of in other ways. But I think the important thing for us is to take a stand in the right direction, say this is an essential service to the communities. We need to serve it, and we need to serve it in the right way. I struggle with misdemeanor because I do think there's an implication that I can issue a citation for $100 or $200 and walk away, and the person can write a check for that and walk away as well. And that bothers me. Where do we set that level? Where do we do something about it? I don't have the best answer. I would love to see us look at something down the line. But I do think it's important for us to take care of our healthcare individuals. And yes, I am biased as well, but that's okay.
Representative Oakley.
Thank you, Madam Chair. I have a motion to amend, and I think it goes to what Senator Cost just said. I think it's a compromise. I think it's meeting halfway, which would be to take what is currently E, which is the penalty provision for assault. So page 6, lines 1 through 4, take that to your 6-month 750 misdemeanor, and then take your battery, which is battery against just anybody, is a 6-month misdemeanor. Take that up to the 1 year, which is the equivalent of interference. Take that up to your 1 year, $1,000 fine. So that is an enhancement for each for this, but it doesn't take it to the felony level. And I do think that's appropriate. We've had some further discussions, and I would just say, I mean, this category of offense, this lower level of either no violence, an attempted violence with assault, or the lower level of battery, I think in all of Wyoming law is that category is a misdemeanor. And I think it's appropriate to keep it that way. If like domestic violence battery, and believe you me, I've seen some bad ones, that's a misdemeanor offense in Wyoming. In fact, they have to get 3 of them in 10 years before we get to a felony level with that. So I just think it's appropriate to keep it in that category. And then if there's an increased level of violence, like let's say they pulled a knife on them, then we have aggravated assault and battery. So if there's other elements that take it out of the misdemeanor category, then those can be charged as such. So this keeps it in the category of misdemeanor, but enhances both of them by an increase of 6 months. So that's I've got that motion to amend to increase those.
Is there a second? Seconded by Senator Cooper. Further discussion on the motion? Does everyone understand the motion? All right. All those in favor say aye. Aye. All those opposed say no. That motion has passed. Senator Kolb.
Thank you, Madam Chairman. I heard testimony that stated that if this bill passed, at least I guess currently the way it's been amended now, it will not deter people from doing what they've been doing in violence against their healthcare workers. And I'll stand opposed to legislation that effectively does not help. Fining folks or putting them in jail after the offense, and you haven't deterred anybody from doing that offense, does not serve the people here who I wish to help, and those are healthcare workers. This is not a means to an end. It's more punitive punishment for actions that I don't agree with, and that doesn't help those people, and I want to help those people, and I don't see where this would do that. So thank you for my chance to comment.
Thank you, Senator Kolb. Further discussion? Representative Washut.
Thank you, Madam Chairman. I still have some concerns about the threat of violence language in this particular bill draft. Correct me if I'm wrong, but where else is that a criminal act other than a terroristic threat?
Where are you looking?
Page 4. A person is guilty of threat of violence against a healthcare worker. Line 23, page 4.
So Representative Washut has a question, I think, to LSO generally, page 4, line 23 through 24. Is there anywhere in law that has similar type language?
Madam Chairman, Representative Washut, I don't know the specifics of each element, but as you mentioned, terroristic threats is one in Title VI. I believe it's an offense against public peace that deals with telephones that mentions communicating a threat as also being unlawful. Beyond that, I'm not immediately aware of any other examples.
Representative Oakley, follow up on that?
Thank you, Madam Chair. And I could just look it up, but if you've got isn't there, like, they have to have the ability, like, there's got to be an imminent threat. Just, I mean, I do share the same concern that, I mean, just verbal without more might be an issue.
Mr. Fuller?
Madam Chairman, Representative Oakley, I just pulled up terroristic threats. It's if a person threatens to commit any violent felony with the intent to cause evacuation of a building or otherwise cause serious public inconvenience, or in reckless disregard of the risk of causing that inconvenience. So I'm not sure if that's gets at exactly how you frame that, but.
Representative Swanitzer?
Thanks, Madam Chairman. It's also in the stalking penalties where you can issue verbal threats or harassments. It's under the definition of harass, but harass is verbal threats that people have reasonable belief would turn to physical harm. So we do have it in some weird places in our statutes, but mostly all in Title VI.
Further discussion? Further amendments? Do you want a little bit of time to think about it? Representative Provenza?
Thank you, Madam Chair. I just wanted to express why I won't be supporting this bill. In addition to, it's not solving or deterring people from committing these acts. It is what we heard from someone who presented was that the CDC said that some of this increase in violence against healthcare workers has to do with socioeconomic status and issues that are happening within society. And I think we do have a problem in terms of how we're dealing with this. I'm concerned in that if this increase and if these are the folks who are committing these acts or these increased penalties are just going to disproportionately affect some of our population that we don't necessarily want to target. I mean, that's true of all of the criminal justice system, but overall, I mean, this isn't going to solve the issue. I think we need to talk about what those real solutions look like. I know that's a difficult thing to pinpoint and nail down, but I want to do that because I do want this to stop. I want to figure out how can we get back to a more healthy outlook on what healthcare workers are, because really ultimately they're saving lives. But this isn't the answer. And we talked about law enforcement having special protections in our statutes, and we heard from law enforcement last time that that hasn't stopped them from being assaulted either. And I want to ensure that the efforts to reduce the risk to our employees and communities who put their lives on the line is taken seriously. And I think this is going to move us in the wrong direction, unfortunately. So I will be voting no.
Okay. All right. So we are behind schedule. So to avoid everyone on the committee to explain their votes, which is certainly we can do, but further discussion on the bill itself, not necessarily an explanation of your own positions, because, all right. Question being called, roll call vote on the bill.
Senator Cooper.
Aye.
Senator French excused. Senator Kolb.
Nay.
Senator Cost.
Aye.
Representative Crago.
Aye.
Representative Larson.
No.
Representative Oakley.
Aye.
Representative Provenza.
No.
Representative Washut.
No.
Representative Rodriguez Williams.
No.
Representative Yin.
Aye.
Representative Swanitzer.
Aye.
Co-Chairman Olson.
No.
Chairman Nethercott.
Aye.
Madam Chairman, I don't know.
Cooper, I don't know.
Well, that bill has failed. Do you want to report the final vote count out? Yeah, I said aye. I voted aye. I voted in favor of the bill. I voted aye. Make sure the public's able to hear that. I voted aye.
Madam Chairman, 5 ayes, 8 noes, and the Senate, 2 aye, 2 no, in the House, 3 aye, 6 no.
House. Yes. All right, thank you. Thank you, everyone, for your time today. We will move on to financial exploitation. Looks like we have a memo. Mr. Fuller, if you'd like to go over that memo with us.
Yep. Madam Chairman, this is a memo at 16-01 in the meeting materials. This memo responds to the committee's request in May for more information regarding Wyoming's Adult Protective Services Act, federal law related to financial exploitation, and then other states' laws on the topic. I'll just kind of cover the high points of each of those three briefly. So the Adult Protective Services Act was enacted in 1981 and generally requires a person or agency who knows or has reasonable cause to believe that a vulnerable adult is being or has been abused, exploited, or neglected, among other things, to report the information to law enforcement or the Department of Family Services. The Act defines a vulnerable adult as one who is 18 or older and unable to manage his money or property without assistance as a result of advanced age, which is separately defined as 60 or older, or a physical or mental disability. The definition of exploitation in the Act means the reckless or intentional act taken to, among other things, obtain control through deception over the vulnerable adult's money, assets, or property. And I think a reasonable inference from that language and that reference to money, assets, or property is that financial exploitation may be included within that definition of exploitation for purposes of this Act. The Act allows the Department of Family Services to provide protective services in response to a request. If a caregiver refuses the provision of services, the department is able to seek a court order, and the department can also seek a court order if there is an emergency and reasonable cause that a vulnerable adult is currently suffering from or experiencing abuse or exploitation. The duty to report abuse or exploitation of a vulnerable adult applies without exception to a person or agency who knows or reasonably should know that a vulnerable adult is being exploited, and failure to report under the Act is a misdemeanor offense. The Act also provides immunity to those persons who file a report or participate in a judicial proceeding that arises from the report. This is 352114. It is that language is included on page 3 of the memo. Importantly, the immunity applies only to those persons whose professional communications would otherwise be generally confidential or subject to the Public Records Act. This immunity provision was enacted in 2002. Since then, I was unable to find any case interpreting the scope or breadth of that immunity. The immunity applies when a person files a report, testifies, or participates in a judicial proceeding, unless that person knowingly or negligently reports information that is false or lacks factual foundation. And it also applies to persons who participate in an investigation or any action resulting therefrom, so long as the person is acting in good faith and, if applicable, within the scope of that person's assigned duties. Unless there are any questions about that state law, I'll move on to the Federal Senior Safe Act. This federal law was enacted in 2018. The law does not appear to mandate any action in terms of reporting, but it does provide immunity from liability in any civil or administrative proceeding for reporting the potential exploitation of a senior citizen, which federal law defines as a person who is 65 or older. The Act also provides that a covered financial institution, generally defined to mean a credit union or depository institution, among others, may provide training to officers and employees of that institution on how to identify and report suspected exploitation. And any person who receives that training under federal law shall not be liable in any civil lawsuit for disclosing the suspected exploitation to a covered agency, If the person served as a supervisor or served in a compliance or legal function, and that person exercised good faith and reasonable care in making that disclosure. The covered financial institution itself is immune from liability for a disclosure made by a person who was employed with the institution at the time of the disclosure and before the disclosure had completed the training that is referenced in that act. The immunity applies only to reporting suspected exploitation. There's no language I could find in that federal law that addresses or authorizes delayed disbursements or transactions. And I was unable to find any relevant case law on this federal provision. In terms of other states, a vast majority of states have adopted model legislation, which I believe was referred to at the last meeting, and which I believe Mr. Meyer provided as, excuse me, as part of his materials for the committee for this meeting. That model legislation is further described in the memo, and with the caveat that each state has adopted that model act with variations and changes and differences, all of which aren't covered in the memo. The model act itself, generally speaking, requires certain persons to report financial exploitation of an eligible adult, and then provides immunity to persons who, in good faith and while exercising reasonable care, reports that suspected financial exploitation. The immunity in the Model Act is civil and administrative in nature. It authorizes disclosure and reporting of suspected financial exploitation to a third party, except that if the third party is suspected of that exploitation, then disclosure would not be made to that person. The Model Act authorizes broker-dealers and advisors, investment advisors, to delay disbursements from an eligible adult's account if the broker reasonably believes that disbursement may result in financial exploitation of an eligible adult. The Act requires immediate, but in no case later than 2 business days, written notice of the delay and the reason for the delay of a particular disbursement or transaction. Delayed disbursements would expire upon the sooner of a determination that the disbursement would not result in financial exploitation, or 15 business days, whichever is sooner. The Model Act provides for the possibility of extensions by applying with a court. And then the Model Act provides immunity for delayed disbursements that are made in good faith and with the exercise of reasonable care. The remainder of the memo covers what other states have adopted in terms of variations to the Model Act. So for example, Colorado defines a person who would be subject to that as someone 70 or older, so a higher threshold age. Some states also require training for a person similar in concept to what is stated in federal law, and ties the immunity to the completion of that training, as well as the exercise of good faith or reasonable care. Some states have extended the immunity to also apply to criminal immunity, so not just immunity that's civil in nature. Other states have more narrowly defined who the law applies to. So Nebraska, for example, enacted a law that applies only to financial institutions, but doesn't provide a mandatory duty to report, as some of the other laws do. With that, Madam Chairman, I would stand for questions.
Thank you, Mr. Fuller. Very detailed memo. Questions of Mr. Fuller? All right, seeing none. Let's go to, I see Senator Case is with us appearing online. Recognize Senator Case. Do we have anyone else online right now? Okay. We'll hear from Senator Case and then bring in Mr. Bishop. Welcome, Senator Case. Good to see you.
Thank you, Madam Chairwoman. It's good to be seen. I'm not going to be to Casper till tomorrow. We're kind of missing our ships passing, but I'm very cognizant of your time and schedule. And I just want to tell you that a lot more work has gone in to research this bill. And I think the conclusion has been that the original bill was very sound, and a great number of people have participated to try to make it a little bit better. We've had the participation of the AARP and the Secretary of State's office, and of course, the Department of Family Services, as well as all this effort has been led by Mr. Scott Meyer with the Wyoming Bankers Association. Mr. Meyer is in Washington, D.C., testifying in front of Congress, but I see that he is online. I think we need to be really cognizant of his time. Mr. Meyer provided several materials, including the Model Act, which it's not a hard and fast model act. It's a kind of a model guideline with variations. I think our bill fits very closely into that. And with some amendments that Mr. Meyer has provided in a draft-in version of the bill, much more closely conforms to the so-called Model Act. I think the bill is supported by a broad range of people, and we hope that you will pass it favorably today. And conscious of your time, I'd certainly answer any questions, but I know that Mr. Meyer has to rush in at various times, and if it's possible, with your indulgence, maybe we could go to him.
Thank you, Senator Case. And just a reminder to the committee, Senator Case, this was your bill that you carried in this past session.
Correct.
Wonderful. Mr. Meyer, welcome. Understand you're pressed for time and out testifying in front of Congress. That's wonderful. So if you want to let us know your thoughts, and be great.
Yes, thank you, Madam Chairman, members of the committee. Scott Meyer on behalf of the Wyoming Bankers Association. We did, in fact, look through that stuff, and I think that Brian Fuller's memo is excellent. After looking through that and seeing what all the other states have done, I think I need to, I guess, make some clarifications of what I had said last time, because about the other 48 states, but there are, in fact, a lot more states that have not put in the freezing of accounts. And so I've attached a schedule that shows maybe here's what overall what the states are doing on elder and financial abuse, and then a second schedule that shows a little bit about what those hold patterns are. And then they go anywhere from 10 days all the way up to maybe even 30. So I think it is all over the board. I think that, like having looked at what we had talked about during the last meeting, I thought I would at least maybe update a few things since that time. We did amend the bill a little bit so that we could include, we had before talked about broker dealers, but because of the research and the Model Act from the NASAA shows on there about investment advisors, and I think that our Wyoming statutes deal a little bit with that. So we made the modification to make sure that those parties are included, and talked about not only just, I guess, bankers, but also the qualified individuals. I know that one of the questions, and I believe Representative Washington had brought up, but I think what is probably the worst case scenario, and after discussing it with bankers and giving it some thought, I think that the worst case scenario right now, if this bill becomes law and somebody actually holds up funds on a transaction, is that, you could talk about interest, you could talk about a lot of different things, but I think it's just lost opportunity. So there is a risk, and there always is a risk. And I suppose that there's a question of whether that lost opportunity would be such that it would be extremely harmful, but I would think that in the alternative would be even worse. And then so that individual, whether it's an elderly person or somebody that's a vulnerable adult, would in fact lose that money. And I think that's the trade-off that we're looking for. There was some discussion, I think, about training, and I will tell you that every bank goes through training, and probably every credit union, every financial institution. It's required under federal law, and it's required by most banks on policy. So they have to know what's going on. So I think that training is there. Each bank and each credit union will probably do it a little bit different. They'll have that as a policy. But I think that every one of the institutions will do their own training and be sufficient to meet whatever regulators oversee what's happening. There was a question about immunity, and I looked at Representative Grego that made a comment, and I think that I looked through that. The question is not only for immunity on behalf of the actions taken by the financial institution, but also what about the actions not taken? And that is in this bill. I'm looking at it provides for acts and failure to act, and I can give you the exact site in that, but I think that is important because honestly, I think that's where I would see most of the trouble. I would not see it so much as somebody reporting what have you, but I could see where somebody looking to a financial institution saying, why didn't you? And so that's why I think that is important in that area. And I know that there was some discussion about documents, and I'm certainly willing to entertain any questions on that and how long. It's not just a 60-day window. It's more like at least 120 days because it goes 60 days prior to the first known questionable transaction to 60 days after the last. So if there was only really one, then you would have at least 120 days. I don't know if there's a rhyme or reason to make that larger or not. I know that there was some comments made about shouldn't law enforcement have whatever they need, and I certainly think that's true. So I think at this point in time, 120 days is out there, but I'm certainly willing to think that can be changed. And then there is that reporting, and of course, we talked a little bit about that and what state law requires and what Mr. Fuller identifies under federal statutes. The immunity that we talked about with respect to reporting would follow those laws. I think that those are adequate. I know that there was some discussion about maybe even molding some of these requirements in with the statutes for Department of Family Services. The immunity really is applying to two things. One is the placing the hold on the transaction, and then the other one is being able to address or whatever as the vulnerable adult may have previously named a third party, as long as that third party isn't the one that's being suspect. But that was my comments, and I'm certainly willing to stand for any questions.
I will. All right, thank you, Mr. Meyer. Questions for Mr. Meyer? How was lunch, committee? Yeah, good. All right. Mr. Meyer, thank you. Probably stay close if you can. Are you committed for the next few minutes, 20 minutes?
I have to step out a little bit, but I will keep this open, and if somebody would be so kind as to send me a quick text, I'll be happy to do that.
Wonderful. If you're available, great. If not, we understand. I appreciate what you're doing.
Thank you.
All right, with that, we will go to the Division of Banking. Mr. Bishop, is he online as well?
Yes, good afternoon, everybody. Apologize, I could not make it in person. I'm at a state bank supervisor conference in Montana this week, but hopefully I can make it in person to the next one. I don't have very many comments on this one. I'll keep it pretty brief. Obviously, this would fall under Title 13, which the Division of Banking administers. However, most of the authority in this bill goes to the Department of Family Services, and I'd say they have much heavier lift than what we would do. Our main responsibility under this bill is mainly to ensure that banks and trust companies develop the appropriate policies and procedures to be in compliance with this bill if it were to be enacted. And I would also point out that this bill, the new draft, I understand, includes broker dealers and investment advisors. Obviously, the Division of Banking has no authority over those institutions, and so we would not be able to review that, but we would be able to oversee the development of those policies, procedures in our banks and trust companies. Other than that, I don't have any questions or comments on this bill. I think it's pretty straightforward as to what the division's responsibilities and oversight would be as regard to this bill, but I would definitely make myself open to any questions that anyone may have.
All right, Mr. Bishop, thank you. Questions for Mr. Bishop? All right, seeing none. We'll be taking a minute and doing some jumping jacks here in a minute. Wake us up for the afternoon. Appreciate you, Mr. Bishop. All right, Mr. Laycock? Welcome, Mr. Laycock.
Well, thank you to the chair and to the committee. I'm Tom Laycock, Associate State Director for Aerp Wyoming, a membership organization for those age 50 and over in the state. We're speaking in support of this bill. I want to thank you for your continuing work to help create protections against financial exploitation and abuse. As legislators, you guys find yourselves in a very favorable position today. You have proposed model legislation that's been signed into law, implemented in a majority of states across the country without major issue. These other states have tested the bill's effectiveness in real-world settings and run the traps to help avoid issues such as you've been raised today. I'd like to compliment the memo on the issue drafted by Brian Fuller of the LSO, who did a tremendous job. It was very well researched on the Senior Safe Act as well as the model legislation from the North American Securities Administrators Association. Thank you, Brian, for a very thorough report. As we look at any bill, we first ask ourselves what the problem is that we're trying to solve. There's no lack of evidence that older adults are disproportionately impacted by financial exploitation. According to a 2016 Investor Protection Trust Elder Investment Fraud Survey, nearly 1 out of every 5 citizens over the age of 65 has been victimized by financial crime. A February 29 report by the Consumer Financial Protection Bureau reported over 180,000 suspicious activities targeting older adults alone, involving more than $6 billion in 2019. Closer to home, the FTC tells us Wyomingites were hit for $7.8 million in fraud losses in 2021, with a median fraud loss of $500 per event. One question that we have heard in debates on this issue is quite simply, does federal law allow banks to stop a suspicious transaction now? Based on our research and that of Mr. Fuller, the answer appears to be no. Financial institutions cannot stop a transaction and expect protection from civil litigation. The Senior Safe Act was passed by Congress in 2019 to offer a carrot to financial institutions who provide training to staff on how to identify and report incidents of financial exploitation, specifically against those age 65 and over. Between the Senior Safe Act and the Wyoming Adult Protection Services Act, financial institutions have civil liability protection to make a report of a suspected financial exploitation. But once again, there's no protection for institutions that place a pause on a transaction. That's what the banks are asking you for today. That's what the Nassau model legislation offers, and we believe that increased protection will help us combat financial exploitation of older people and vulnerable adults in Wyoming. As of July 2021, the Nassau bill has been adopted in whole or in part by 34 states. Among those states enacted are Texas, Alabama, Utah, Oklahoma, North Dakota, Nebraska. We're fortunate to have one of the members of the Nassau Legislative Committee working in the Wyoming Secretary of State's office. She was nice enough to make some calls to some of her colleagues in other states that have implemented this particular bill to ask if there were large-scale concerns or problems with the model legislation's implementation. The feedback received mirrored that of Mr. Fuller's report. No state has repealed one of these laws after passage, and there have been no large-scale overhauls of this legislation after it's passed. As Mr. Fuller points out, many states use components of the model bill and sort of make it their own. However, 2 things that these types of bills have in common almost universally are the ability to pause a disbursement when a broker-dealer exercises that discretion, and immunity from lawsuit for doing so. Education is core to our fraud prevention work. As you know, AARP Fraud Watch Network sends monthly scam alerts to its members and the public at large. We do this because research shows that people who know about a specific scam are 80% less likely to engage with it. Another tenet of our fraud work is our call to stop, think, and verify if someone thinks there's a chance they might be on the other side of a scam. We feel this bill will allow for a similar opportunity for financial institutions to slow a transaction when there's concern someone is in danger of being financially exploited. So I'll close by saying thank you very much for your consideration of this important bill to help protect those who are unable to protect themselves. And I'd be happy to stand for any questions.
Thank you. Questions for Mr. Laycock? All right, seeing none, thank you so much. All right, further public comment on this bill? All right, please come forward, Director Schmidt. Welcome.
Thank you, Madam Chairwoman, members of the committee. My name is Lindsay Schilling. I'm the Social Services Senior Administrator for the Department of Family Services. So what I have today are just a few general comments for your consideration. We're incredibly thankful for the focus on financial exploitation and the impacts it has on vulnerable adults. And anytime there's an effort to reduce barriers to successful substantiation and prosecution of these cases is a good thing for the agency. So our focus really was on a technical read of the bill and looking at the intersection between Title 13 and the Title 35 provisions under the Wyoming Adult Protective Services Act. And there were just two things that I wanted to be sure and mention. The first one is on, I believe, page 4 and 5 of the bill. It's 1310-402. And if you follow that all the way down to the bottom of section B, where it talks about the financial institution shall report required by this subsection not later than the earlier of, and then it gives two options. Our read of this is in that this reporting timeframe is in conflict with the expectation under Title 35 that reports be made immediately when they come to someone's attention. And that kind of falls then under the duty to report statute that was cited as well in the memo. So just an ask to consider that and the potential conflict there. One thought that we did have just as an easy correction, just delete everything starting with that sentence in the option 1 and 2 and leave it as submit a report to the department in the same manner as and containing the same information required to be included in a report under Wyoming statute 35-2103, period. And that takes care of that.
Ms. Schilling,
Yes.
can you please restate that with very specific specificity so someone can potentially bring a motion?
Certainly.
Committee members?
So I have it on page 4 and 5 of the draft bill, starting on line 15, 16, and 17 on page 4, just leaving that as it's written, continuing to page 5 as written, to be included in a report under Wyoming statute 35-2103, period, and delete the rest of those lines through 10 and just have C be the next piece of that bill.
So strike lines 19 through 10.
Yeah, the last word in line 18 and then 19 through 10.
Okay.
And that just maintains the expectation of immediate mandatory reporting for financial exploitation cases. And the only other thing was on the very last page, section 2. The Department of Family Services shall promulgate rules necessary to implement not later than July 1, 2022. If we could update that. We don't want to be in trouble as soon as this is enacted. So. But that's really it.
All right, thank you. Thank you for your testimony. Director?
Madam Chairwoman, members of the committee, Director of the Department of Family Services. I just wanted to maybe make a comment in regard to the Wyoming Division of Banking's comments about moving this piece of legislation under Title 35, which are the Adult Protective Services statutes. Not to get in a battle with my colleague, but I would prefer that they stay where they are. I have a concern that banks wouldn't necessarily go to our statutes to understand what maybe their duties are. Certainly that's not a deal breaker, but I do think it would create a little inconsistency about what banks are required to do if they had to drop over into the APS statutes as well. And that's it. Thank you.
Further questions for the director? All right, seeing none. Thank you. Further public comment? Anyone online? Okay. Mr. Fuller?
Yeah, Madam Chairman, I do want to offer one minor clarification. The bill that is in front of the committee is simply the engrossed version of Senate File 76. At the last meeting, the committee, I don't recall if it was a motion or not, but the committee did not ask for a bill draft for this meeting.
Thank you. Very helpful. That's why it looks the way it looks. Yeah, thank you. Further, okay, public comment is closed. Committee, back to you. We do not have a bill draft in front of us. As a reminder, there's an example of Senate File 76 with those proposed changes, I think in red, that were created by somebody. To the members of the public and who participate, it is actually not helpful to try to take how LSO provides a bill draft and then present it to the committee for review. It's very confusing. So it looks like that was maybe worked and then presented to us as a potential amendment to what Senate File 76 would be. Is that right?
Yeah, Madam Chairman, I believe that language was just inserted, I think, as a proposal, should the committee move forward with the bill draft. And really the concept there is just to include broker dealers and investment advisors in the bill.
Okay. All right, thank you. Senator Case, briefly, did you want to make a comment?
Madam Chairman, that's exactly correct. This bill draft is based upon the engrossed version as it came from the House. There was one amendment it came from the Senate. And Madam Chairman, there was one amendment that was in the House that is not in the engrossed version. And if you want me to throw it out there, it's how it came out of the second body, but it would be page 8, line 8. And if you go to page 8, line 8, I believe there's a 10-day limit there. And the House Labor Committee on line 8 took out the word expires on page 8, line 8, and said shall not exceed 10 days. We were okay with that change, but that was something that was done by our good friends down the hall.
All right, thank you, Senator Case. Questions about that from the senator? All right, appreciate that. Representative Monitor?
Thanks, Madam Chairwoman. I would move that we take, the bill draft in front of us with the proposed changes in red and ask for those to be incorporated for a bill draft at our next meeting in LSO reporting form with the motion, add in that change Senator Case just mentioned on the not to exceed 10 days there on page 8. And that'd be my motion.
Moved by Representative Zwanitzer, seconded by Senator Cost. Further discussion?
Madam Chairman, if Senator Case would be willing to repeat that change on, I believe, page 8, line 8 one more time.
Senator Case? And it was an amendment made in the House Labor Committee during this past session. Is that right?
Yes, Madam Chairman, it was the Standing Committee amendment, which did pass on the floor of the House. And so it was on page 8, line 8, where it says section expires 10 business days. Take out the word expires and insert shall not exceed 10 business days. And I don't know how folks feel about the proposal by the Department of Family Services. Sounds reasonable to me. And you may want to incorporate that in the draft as well.
Are you a chairman, Senator Case?
It used to be, Madam Chairman.
All right. So there is a motion for a bill draft right now. Is there anyone that wants to make amend Representative Zwanitzer's motion to include that in that bill draft? Senator Koss would like to do that, seconded by Senator Kolb. Does everyone understand? Representative Zwanitzer finds that friendly. So does everyone understand what's happening? I think Mr. Fuller, you have the lines proposed by DFS? Great, okay. Everyone is clear? Everyone is awake? All those in favor, please say aye. Aye. All those opposed say no. That motion has passed. All right, committee, we are now moving on.
Thank you all.
Thank you to our topic number 17 on the agenda, bill drafts, which is a series of bills. And committee and members of the public, we have as our last item of the day at 4:30, traffic offenses, which the co-chairman and I have chosen to remove from the agenda. If there's time, based on the end of the day, we may discuss that for our third meeting, but it will not be on the agenda for review. So members of the public who are watching or may be staying for testimony on that, we will not keep it on the agenda for today. That's traffic offenses, civil penalties. So I think very few people in the room probably are aware of that, but we are striking number 17 from the agenda. And we are going, or there's two 17s on the agenda, 18 on the agenda. And so with that, committee, we're going to take a 5-minute break because you need some blood flow. We'll be back at 3 o'clock. All right, members of the Joint Judiciary Committee, we are back live, working on our last topic for the day, which is number 17, bill drafts. And as you recall, committee, these series of kind of unconnected bill drafts are in response to Wyoming Supreme Court opinions where we have identified potential legislative action that we can take to help make our laws cleaner and address those outstanding concerns. So with that, we will start with LSO Bill Draft 95, Interlock Device Petition for Relief, Discretionary Hearing. Mr. Fuller?
Yep, Madam Chairman, members of the committee, this is 17-01 in the meeting materials. This bill draft is a response to the Supreme Court's opinion in Schneider versus State. In that case, the court held that an applicant, so a person who was applying for relief from a lifetime requirement to drive vehicles only equipped with an interlock device, that an applicant is entitled to a hearing because the legislature, in enacting the statute that's in the bill draft, intended that an applicant be entitled to that hearing, make a good cause showing, and provide relevant evidence. After discussion, the committee moved for a bill that would specify that a court may hold a hearing at its discretion on a petition for relief from the lifetime interlock requirement. On page 2, line 15 and 16, the bill amends 31.5.233F5 to do just that, to just say that the court may, in its discretion, hold a hearing on the application for removal of that device. With that, Madam Chairman, I'll stand for questions.
Fuller? Representative Zwanitzer?
That's a weird one. Thanks, Madam Chairman. Even though it'd probably be unlikely, if you did get an expungement, would you still be required to comply, or would having the, let's say, the fourth, or any one of the, I don't know how this would work when you've had subsequent convictions, but if any of those convictions, A, got overturned or expunged, what happens? Or if your fourth one gets expunged, does it automatically negate this section then, or how does that work in practice?
Mr. Fuller, we also have the folks from YDOT here, as well as experts. So I'll bring you forward now, and we'll refer the question to Mr. Fuller as you come forward.
Yep, Madam Chairman, Representative Zwanitzer, I'm not sure about the expungement question. If, a conviction is reversed on appeal, obviously that would not be a conviction for purposes of the statute, but I am not sure how expungement would operate in play with this statute and requirement.
Wonderful. Additional questions for Mr. Fuller? Senator Cooper?
Thank you, Madam Chairman. Mr. Fuller, as I'm reading this bill, all this is doing is adding the line that says the court may hold a hearing. Is that correct, that the court did not have the ability to hold a hearing before? Is that correct?
Madam Chairman, Senator Cooper, the court, I think the court has always had the ability to hold a hearing. What the court held in a particular opinion that the committee considered in May was that the court must hold a hearing for that applicant. That it, after that applicant made a prima facie good faith showing that, or a good cause showing that, they were entitled to remove the requirement, then the court had to have a hearing. This makes clear that it's completely discretionary for the court to hold a hearing.
Further questions? All right, with that, we will go to the Department of Transportation. Welcome. If you'd introduce yourselves to the committee. And
thank you, Madam Chairman. Taylor Rossetti, Support Services Administrator, and I have with me today Misty Zimmerman, the Driver Services Program Manager. Thank you, Mr. Fuller, for that explanation of this. Our eyes blew up when we saw this because it continues some work we started in 2020 and 2021 on some DUI legislation specific to this, and I think that we certainly understand where they're coming from with this. We can say that the removals actually started, I think, in 2016. The legislation for interlock, I think, dates back to 2010 or 2011. So that's about when they started. It's been hit and miss. I think the department's perspective on this is we would like potentially the ability to be notified when they do file for these removals, just so that we can be prepared and provide the courts with the information they may need to help make the decision. And we'd also maybe ask that we have some specific rulemaking authority for potentially establishing what the venue for that petition might be. I think there's some instances where a DUI conviction in another state may arise, and they would still need to petition a Wyoming court likely to get this removal. We might be able to address that in working with the judiciary in rules and regs. And that's really what I'm here to say. Ms. Zimmerman does have some additional information that may help you guys as you work through kind of the universe of these removal hearings and kind of what that looks like from our side.
Okay, so Mr. Rossetti, just to help me understand your testimony, make sure I heard what I think would you be asking us to maybe add some sections to this requiring the defendant to notify YDOT of this process? Is that missing currently?
Madam Chair, it is. I think specifically what we'd be asking for here is there on page 2, line 15 after the word paragraph before the amendment you guys are considering here, simply entering and shall provide notice to the department. That would allow us to start preparing for that hearing for the court. And then again, there on page 2 at the end of line 22, just insert that the department shall promulgate rules for the administration of this paragraph. With those 2 additions, then what it allows us to do is be notified. It then allows us to establish those rules, and we could be better prepared for the courts if those hearings are conducted.
All right, thank you. Ms. Zimmerman, thank you.
Madam Chairman, again, Misty Zimmerman, Driver Services Program Manager. In response to Representative Zonotzer's question about expungement, I have to be completely honest with you. In practice, I cannot give you an answer right now, but I will report back to the committee with what would be that situation if in fact one of the 4 were to have been expunged. My initial reaction is that the administrative interlock requirement would stay, but I would need to confirm that. So I will in fact do that and report back through Taylor, Mr. Rossetti, for you there.
Mr. Fuller, Mr. Hopkinson, did you look at the expungement statute? Is it expungible?
Madam Chair, I'm still looking at that, but generally speaking, I would think if it were expunged, in order to obtain an expungement on a lot of things, there has to have been a certain amount of time that has passed, and there can't be any ongoing cases of that nature. So I wouldn't think you'd qualify for an expungement with something like this still pending. I don't think a court would grant that. Now, if they had a previous expungement, that wouldn't show up in their records anyway. So if you had something 30 years ago that had previously been expunged, that may not count as a prior conviction. But I don't think there would be a way to dodge this, getting an expungement at the same time you've got something like this pending.
All right, anything further?
Yes, Madam Chairman. Since 2016 up until the current date 2022, we have actually received the removal of 73 lifetime requirements have been removed. Of those, 19 YDOT was involved in, and that's it. So what we would like to do, and obviously with your consideration, is to look at what is provided to the courts so that we would ensure that that decision is made with all the information. Of the 19 that have been that we've been notified of, and of the 73 that have been removed, 9 of them have had recurrent subsequent alcohol-related issues and have been returned to an ignition interlock status.
All right. And that's since 2016?
Correct.
Representative Washut?
Thank you, Madam Chair. I thought I heard some question about concerns of other states conducting these hearings. Would you elaborate a little bit on that?
Madam Chairman, Representative, yes. Because this is a Wyoming statute, it is our requirement. So if a constituent were to receive a DUI in another jurisdiction, that would subsequently cause the lifetime interlock requirement in Wyoming, because Wyoming is their state of record. It would be very difficult to have that person try and go to an out-of-state court to try and remove a Wyoming requirement. So then we would be able to, through promulgating rules, direct that person to the appropriate court to have that restriction removed if they were therefore entitled to.
Because the ignition interlock device is not a criminal penalty. It is a civil penalty associated with the privilege of having a driver's license. Is that right? And there's a national driver's license uniform law.
Correct.
What is it called, actually?
The driver's license compact or the non-resident violator compact. Yes.
Great, thank you. Further questions, Representative Washit?
Just a quick follow. Is there a need to change any language in this draft to accommodate this out-of-state situation, or are we good?
Madam Chairman, Representative Washit, I believe that that's what we would be able to promulgate through the rules. So I think if there's some consideration to grant us that authority to make that rule, that's what we would probably address there.
Senator Kolb.
Thank you, Madam Chairman. Amongst those 9 reoffenders, was YDOT at any of those hearings?
Madam Chairman, Senator Kolb, it's my understanding that 5 of them were prior to 2018, which 2018 was the first case that we were involved in, and the remaining 4, we do not believe that we responded to at all.
Thank you.
Representative Craigo.
Thank you, Madam Chairman. And this might be a question for Representative Oakley, also for the department. So when the interlock gets imposed, I've always thought that was part of the judgment and sentence following. Is that, or can it be part of the judgment of sentence? It always is administrative. Okay, thank you.
Welcome. All right. It's 2 tracks, criminal, civil. All right. Further questions, Representative Zwanitzer?
Thanks, Madam Chair. Can I just get a little more information on why or what happens at these hearings that you would want to be invited to? You present what kind of evidence would you present to the judge to encourage or discourage? Are you a party in the case? I'm trying to understand what YDOT's role would be in the hearing and why you would show up, and if it would be to the positive or negative to the applicant. So better idea of what it is you do when you go to these hearings.
Why do you want notification, YDOT?
Madam Chairman, Representative, what we have done is we've developed a process that we basically would present a package. We wouldn't necessarily be required to appear at the hearing, but we would present a package based on existing MVR as well as logs from the device that may indicate that there has been infractions on that person's ignition interlock device, and that way the court would then in fact have all of the information that would be required if in fact they were to consider that.
All right, further questions from the committee? All right, seeing none, thank you both. Further public comment on this bill? Anyone online? Okay, seeing none, public comment is closed. Committee, back to you. Moved by Cost. Is there a second? Seconded by Cooper. Discussion on the bill.
Madam Chair.
Senator Cooper?
Thank you, Madam Chairman. Going back to something as simple as reading the bill, the title is very direct. The changes it makes in the bill are very direct. If there's things missing in the original bill, they're not in relation to this bill. All this bill does is give the court the authority to hold a hearing. I think the 2 things are not related, and even though they are similar, the corrections to the original bill need to be made to that statute rather than on this one. Thank you, ma'am.
Mr. Fuller, thoughts about that? Can we make the amendments requested by YDOT within the title scope of the bill?
Madam Chairman, at this point, the bill has not been introduced. So those limitations on amending a bill beyond its title do not apply because the bill hasn't been introduced.
Theoretically, if it was, what would you think?
I'm sorry?
Theoretically, if it was, what would you think?
The bill, I will say the bill title as drafted is quite narrow at this point. Of course, once again, though, hasn't been introduced, so it could be that could be changed. I would offer a note on this section. This section, this 315233F5, really deals with an applicant's ability to apply to a court. And so I'm unsure about rulemaking authority for an executive branch agency when all this paragraph talks about is, the process by which a person may apply and the resolution of that by a court. Certainly if there's, if the committee desires to add mention of notice, perhaps there may be a need there, but even then I would think notice to the agency would be typical as given to any other state agency.
Representative Craigo?
Thank you, Madam Chairman. I guess that's where I was going with my questions a few minutes ago, is it appears to me we'd be trying to create a jurisdictional and a venue statute through rulemaking, which I'm not sure we can do, or I'm not sure the department can do. If we're going to create some sort of jurisdictional or venue-based statute, then we probably have to do it within one of our own statutes. That's what I was trying to get at. I mean, and a bigger question is, how do, currently, I mean, obviously you can apply for this, but I've never done one. Never responded to one. I don't know anything about it, but seems like I don't know how we have jurisdiction currently on that case. It was not before, and maybe there's a separate statute that provides that jurisdiction. I don't know the answer to that, but I'd be interested to know.
It's the driver's license compact. Is that right? Why not?
Misty Zimmerman, just again for you. The driver's license compact allows us to communicate information between jurisdictions back and forth. So if someone were to obtain a DUI in another state, we would be the state responsible for administering the penalty associated with that, both on the administrative side as well as the driver's side.
Representative Craigo?
Follow up, Madam Chairman. So I guess my question is this on a bigger picture, and it might not be for today's purposes, but should that application actually be going back to the department for the removal rather than to a court?
That's probably a policy question. The department might have a different opinion than the applicant.
Madam Chairman, I think I would tend to agree. That's certainly a policy decision here. It seems that previously the policy was that the court be involved in that process. I think that the question that I have to your question there, Representative Craigo, or the point that I may make is I think looking there on page 2, line 10, this section does pull in 317401 through 404, which is the ignition interlock process. I think as I'm thinking through this, that's where I would build the argument that it seems like we do get pulled into this because of that reference there in relation to court action. That 401 through 404 is truly the administrative action for ignition interlock. In 401, we actually do have some rulemaking authority for the issuance, but we do not have rulemaking authority for the removal. So that's really where we were building our thinking, is that this might be an appropriate place for that. Again, there's that administrative action specified in this section of statute. Notify us, we'll provide the court with some information within our rules and regulations, then we can make it clear what we'll provide, and that was pretty much where we would leave it.
Representative Oakley?
Thank you, Madam Chair. Okay, so we're looking at this. So this is in 315233, specifically F.
It's 2 tracks.
5, which is what says you can take it to a court. That's what we're dealing with. But then it does refer back to the ignition interlock statutes, the 401 through 404 that you've talked about, and that is completely with the department. So I'm with Representative Craigo in that I'm confused. All of this is via the department.
You need a defense attorney?
Pardon me? What'd she say?
So do you need a defense attorney?
So it seems to me that if it's going to stay with the department, then maybe this shouldn't be in 315233 and reviewed by a court and should remain solely, and the change we need to make is that it remains with the department. What am I missing?
So I think 315233 is the DUI statute, right? And depending on the number of what you are convicted of under 31, under the DUI statute, it's been a minute, whether or not the ignition interlock device is even applicable. It's not automatic, right? So the department administers the requirement of the ignition interlock device based on the privilege of your driver's license, right? And so, but they don't, and then there's a lifetime prohibition on it for your fourth. This applies to the fourth or subsequent conviction, which requires then a lifetime commitment. It would be, I think, inequitable. So a driver's license hearing, right, goes to the Office of Administrative Hearings to have a contested case hearing before your driver's license can get taken away, or even an ignition interlock device can be placed. You have the right to a hearing with the Office of Administrative Hearings. So there's this third-party arbitrator making that determination, and the entire discretion is not left to the department. So if you wanted to do that here, I think that's a larger conversation about the discretion you want to give to the department in this regard, or if a court is more appropriate. Representative Krega.
Madam Chairman, I just want to reiterate my confusion a little bit because we are dealing with a criminal statute here. I understand the interlock is civil at this point, but the statute where we go back to the court and ask for removal of the interlock every 5 years, which is what the bill draft we're talking about today, will be brought in a criminal case. I mean, when you bring your petition, I assume this is how it happens. If you go back on do you bring it under the existing criminal case, or do you bring a whole new petition to the court referencing your old criminal case, your old criminal conviction, and ask for relief under the statute? I'm not exactly sure what the procedure is. I'm just thinking about jurisdictionally in front of a district court judge. And this isn't necessarily a question we're addressing today, but it's the one that's popped into my head, is how does that all work from a jurisdictional standpoint for our district courts? What's the interplay there, and are we actually, do they even actually have jurisdiction to do what we're asking them to do?
Mr. Fuller, you seem to, I think it's just a civil action petition for relief.
Madam Chairman, with the caveat, I pulled up the docket for Schneider's case, and I only have access to the final order. It is docketed under what appears to be the original criminal number. It's CR 2013-2DC. So it was petitioned. It looks like it's a criminal number. That final order was served to the county attorney, the attorney general, YDOT, and a defense attorney.
Looks like they followed expungement.
Madam Chair and Representative Crago, Representative Oakley, I might have been thinking about this more simply, but I'm a simple guy. What I'm looking at here and the way I was thinking through this is okay, this is an actual administrative penalty that is related to that conviction, that criminal conviction. So administratively to me, basically, I know that you've got a lifetime interlock requirement, and administratively, that's all I would ever have to do, right? I could keep that on you forever. It does seem appropriate to me, in order to not have to be always the one sorting this thing out, having the court then be repetitioned in order to make the determination as to whether or not that administrative action should cease. I think the way it's set up, if it is legal, does functionally make sense to me, because it is a criminal action that leads to an administrative penalty. It seems like that criminal venue should then say that administrative thing needs to cease. That was just how I was thinking through this in my head. Whether or not that's allowable is unfortunately your guys' decision.
I think it can happen on either docket. In a new civil petition, like a petition for expungement, for example, is not in the criminal case. It's a new, fresh action with a civil docket number, petition for expungement, served upon the parties pursuant to the expungement statutes. But it probably can happen in either way, because it's the same result. Mr. Hopkinson, do you think that's wrong? It's been a minute since I've practiced here.
Madam Chair, I can't confirm or deny that, so.
Prudent. All right, further questions from the committee? Further discussion, there's a motion to adopt this as a bill draft. Representative Washit?
Thank you, Madam Chair. I'm just wondering, we've asked a bunch of questions. I'm wondering where might a source of answers be that perhaps we could have come before us in November to fill in the deficit of our understanding about this process?
Representative Swanitzer?
Thank you, Madam Chairman. Let me go back to the bill and tell you why I don't like it and why you shouldn't either. So the reason we have the bill in front of us is based on this court case, because when we set this statute in place, we allowed, even though it was a lifetime event to put this on, we allowed a petitioner every 5 years to at least be able to petition the courts. What we had is a judge saying, I don't have to actually hear your petition, not going to do it, it's on, right? And so the question before us in this bill is whether or not a district judge, assumably a district judge, has to hold a hearing when someone applies, right? So it's been 5 years, petitioner applied, the judge said, I have a really full docket, I don't know why the judge denied it. The judge, for whatever reason, said, just because you petitioned, I don't actually have to hear your petition. So the question in my mind is either A, we say, yes, a judge, if after 5 years, must hear, whether you like it or not, the application to get this removed, or we say, in my mind, it's a lifetime event, it's on there, like a sex offender status. But what I really, really don't want to do is exactly what this bill does, is say that each individual district court judge in their discretion gets to decide whether or not to hold a hearing. I mean, I think every judge should be treated the same. Either you must hear it, or we're not allowing this provision we put in place 8 years ago to hold that you even can have a hearing. But to have each judge in my mind say, yeah, I'll hear your petition, or say, I don't want to hear it, is not the right place for the legislature to go. And that's the question, I believe, what brought the bill. And my learned attorney, the other end of the table, is going to jump in here.
Representative Oakley?
Thank you, Madam Chair. And it is just policy, but I wholeheartedly, diametrically am opposed to exactly what you just said. So we've got our, we have our district court judges here yesterday. We are currently setting civil trials in district courts in Fremont, probably others are similar, in December of 2024. The next settings will be in 2025. To understand what district court judges are doing every day, all family law, all juveniles, all criminal, anything big civil trials. And now we have felony DUI offenders that are gonna run the show. The reality is, if we want to hold to the statute, it says it's a lifetime. And here they are, but it's been 5 years, so you need to review my petition. Judges should have the discretion to say, no, I've seen your record, I know you're a 0.3, I convicted you, I'm not hearing that right now. I think we need to, I like the intent of the bill that there is discretion. They have information in front of them. If they don't think it's appropriate and they don't need to have a hearing, then I think we should leave that. Or I said this last time and people acted like I was crazy. We could just take it away and say lifetime's lifetime. You don't get to go to the courts every 5 years. But if we do, I certainly think we need to give the discretion. And then, of course, Representative Crago is probably going to say, I think there's still some problems here anyway.
Okay, so what is the current motion, Co-Chairman? Can you call?
I don't think there was a motion.
All right,
Interrupted you in the middle of the motion.
so there's a motion for a bill, or there to approve this as a roll call vote to adopt it as a committee bill. The current question, I think, before the committee is whether or not to make a motion based on the request from YDOT and their concerns to be notified when an applicant is requesting this after 5 years. Does anyone want to make a motion to respond to that concern from YDOT, allowing them to be notified? So I want to I think it's a reasonable request from YDOT to be notified. So Representative Craigo, if you agree, I need you to make that motion.
Madam Chairman, I'm not exactly sure where we would slide that in there. I guess on line 13, page 2, line 13, after the word thereafter in the comma.
I think Mr. Rossetti provided that language to us. Mr. Rossetti, if you would, and then we're kind of going out of order. Page 2, line 15, I think, is where they requested it.
Madam Chairman, Representative Craigo, yes, we were in the same sentence. We were just sticking it there at the end after the word paragraph, just finishing that sentence with, and shall provide notice to the department.
Oh, geez. Representative Craigo?
If that's the motion you would like, Madam Chairman, that's what we'll go with. Here's my concern. It just,
You can discuss it.
Thank you,
Thank you.
Mr. Co-Chairman. All I was going to do was put it at the beginning of the clause so that you had to provide notice before you could apply, or at least at the same time, because if you say after the fact, it says the offender may apply to the court for removal of the ignition interlock device required by this paragraph and provide notice to the department. That could all happen in a matter of days or hours, right? You walk in, get handed to the judge looks at it and says, yeah, I'm gonna grant that, I don't need a hearing, I know this so-and-so person. The opposite effect of what Representative Oakley was talking about. I just want them to have notice prior to the approval, that's all. If we're gonna do it, then that's why I was gonna put it at the beginning of the clause rather than at the end.
That sounds wise, Representative Craigo. So let's put it at the beginning. What's your motion?
Thank you, Madam Chairman. Page 2, line 13, after the word thereafter and the comma following that, insert the words upon notice to the department, comma.
Seconded by the co-chair. All right, discussion by the committee. Question being called. All those in favor, please say aye.
Aye.
Any opposed, say no. That motion has passed. Committee, back to you. Any further amendments? You have a question on the bill? Discussion on the bill? Senator Cost?
Thank you, Madam Chair. I might be out to lunch, but what's the value of what we have in the red then? I mean, it sounds to me like we don't need to tell the court, it's your discretion, you may or may not. They should either know that now, and I don't know what the value is.
So committee, if you recall, in our last May meeting, we reviewed the Wyoming Supreme Court opinion of Schneider versus State of Wyoming. And in that case, the court elected not to have a hearing because it wasn't required in statute. And the applicant appealed the denial of the court's decision to not remove the interlock device and not have a hearing. And the Wyoming Supreme Court supported Schneider's statement and said, you're right, the court is required to hold a hearing in order to determine what the ambiguous language of good cause may be. And so a hearing has to be held to determine good cause shown, because language like good cause shown is ambiguous. Don't do it. But that's what this case was about. And so now the question before the committee is whether or not the district court should be allowed to choose whether or not to have a hearing when an applicant provides a request. And so Representative Zwanitzer is opposed to that and thinks that the court should be required to do it every 5 years and what the applicant wants. And Representative Oakley has said, No, the court should not be at the whim of every time a DUI interlock device defendant wants to have a hearing every 5 years, that the court has to conduct that hearing. So that's the two testimonies that you have heard from two competing viewpoints. Representative Provenza?
Thank you, Madam Chairwoman. I guess then the argument for the courts being overburdened by requiring a hearing seems moot, because they've already essentially been operating as having that while preserving folks' ability to be able to petition the court to maybe have it removed. So I think I agree with Representative Zwanitzer that if it's not going to burden the court anymore, we're already operating this way. Why are we going to change it so that we're taking people's rights away to petition the court?
So clarity, we're not taking anyone's rights away to petition the court. You're taking the mandatory right for them to have a court hearing. So they can still file a petition and request the court, and the court can do so without a hearing. The court can grant it without a hearing, and probably does so in all of the times that Ms. Zimmerman pointed out. How many ignition interlocks device have been court authorized removal in the last number of years? 70.
73, sir.
73 times the court has removed an interlock device based on good cause shown, with or without a hearing, we do not know. So there's no rights necessarily being taken away of their ability to ask. It's just their ability to demonstrate to the court in an evidentiary hearing, proving what good cause may be. Senator Cost.
Thank you, Madam Chair. But if the court said they have that right to have, request that hearing, why wouldn't it, instead of may, honor whatever the decision of the judges was?
Because we're the legislature.
Okay.
Representative Craigo?
Thank you, Madam Chairman. Just to maybe respond to Senator Kost's question, because I think it's a little confusing. What the way I read the opinion, what the Supreme Court said was, look, it's not, the statute as written does not give the court discretion. We're not saying they shouldn't have discretion. As written, they don't have it. And so that's why it was brought to our desk to look at and say, do we want to give the district courts discretion to say yay or nay without a hearing, to whether or not to even have a hearing? And I would also add, lots of things get decided in district court without hearings all the time. I mean, we make motions, they get decided without hearings on written pleadings all the time. That does not make, on motions, it does not make this unique. It's just whether or not we're making it mandatory, they have to give court time to the applicant.
Representative Yen.
Madam Chairwoman, thank you. So reading Mr. Fuller's memo from May about the committee considerations and what we may wish to consider, one of them was whether a district court must articulate findings of fact in deciding whether to grant or deny an application for removing an interlock device. So in the case of Schneider, where he was denied a hearing, did the judge at least tell him why his hearing was denied and his petition was denied?
Madam Chairman, Representative Yen, the order that denied the petition for relief really comes down to a single sentence that denied the order, or that denied the petition.
So Madam Chairwoman, my biggest issue with not having a hearing is if there's no requirement to at least tell the petitioner why their application was denied, they don't have another chance to do that for another 5 years. So they don't know what a judge would actually consider good cause. So if you punish them once every 5 years and you don't tell them why, it just feels like another punishment for 5 years, essentially, without being able to determine what is good cause for them to be able to come back in the next 5 years and determine whether they actually qualify for it. So I don't necessarily think that you have to require a hearing, but I think there should at least be a reason why the petition was denied in full. Thank you, Madam Chairwoman.
Further discussion? Representative Washut?
Just for consideration, it seems there's a third option before us, and that would be to amend the interlock statute to do away with the 5-year reviews and just say lifetime means lifetime, period, done.
So two things from Representative Yan and Representative Washit. Both of you have presented ideas. Do you want to turn them into motions?
Madam Chairwoman, sure. I'll make a motion to strike the new language in the draft and replace it with, keep the new language in the draft, but in addition, require the court, if they do not hold a hearing, to explain in their petition why the petition was denied. To explain in their dismissal or whatever the court procedure is to the petitioner why the petition was denied.
Seconded by Provenza.
Does that make sense to LSO?
Representative Grego?
Thank you, Madam Chairman. Well, that might take as much time as the hearing itself. I mean, and on top of that, there's there's an appeal right? And so if you appeal the denial, you go to the Supreme Court and say, well, I don't even know why it was denied. It's probably going to get overturned anyways. I just think it's a waste of language within the statute. And it's, it just doesn't serve any purpose because of the right to appeal. You already have that right. And that's probably part of the reason in this case it was, I mean, I'm not sure it is or not, but it's one of the reasons it probably was overturned and sent back, was because they didn't know why it was denied.
So my understanding of the case, which is really what triggered this issue in the first place, was the language of good cause shown. And so there's three requirements in order to receive the release of the ignition interlock device. 1, 5 years has to pass, right? 2, no other convictions. And then 3, good cause must be shown. There's no definition of what is good cause. And so the court is left to determine what is good cause, and the legislature gave that to the district court's discretion to determine whether or not there is good cause, with no guidance on what that should be. The Supreme Court said there's no way that a court can do that without conducting a hearing, an evidentiary hearing where the court will take testimony from the party to demonstrate good cause. That's what it is. And so the question before this committee is whether or not a court can determine good cause without having an evidentiary hearing. So there's a couple of ways around that, I think. We define good cause more specifically, which I know is difficult to do, or we get rid of the good cause demonstration and we say, you have complied for this period of time with no further related convictions. And therefore, this kind of discretionary piece, which no one quite feels comfortable with, because this is a 4th-time felony convicted DUI offender that is a danger on the road without some of these safety precautions in place. Representative Washit?
Taking the silence, I make a motion that we table further discussion on 23 LSO 0095, working draft .5, and ask for a bill draft that would change the.
Let's just deal with your motion to table, which is.
Motion to table.
Is there a second? It's non-debatable. All right. All those in favor say aye.
Aye.
All those opposed say no? No. Okay, we're done with that bill. Representative Washit?
I make a motion that we have LSO create a bill draft that would eliminate all language in the DUI penalty statutes regarding the interlock device having a 5-year review period and showing a good cause, that basically the language would say, if you're given a lifetime interlock, it's lifetime interlock.
Is there a second? Seconded by Representative Oakley. Further discussion? Senator Cooper.
A lifetime interlock for Representative Craigo or Representative Oakley is a completely different sentence for than a lifetime interlock for Senator Cost or myself. I think there needs to be discretion for a way to, if a person has done the right things and has met the requirements, I think there needs to be a remedy for that. Thank you.
Thank you, Senator Cooper. Further discussion? Representative Zwanitzer?
Thanks, Madam Chairman. I would just say I was here when this was written, and that was the exact reason why we allowed this 5-year extension, because some people really do truly turn it around. I would also say we didn't have the expungement. We've moved up a lot of these in the last 4 years with our access to justice to be able to have people expunge things, but I didn't hear that an expungement of one of these convictions would automatically negate this section. And so until LSO tells me it does, I think I don't agree with the bill draft, and I think there should be an every 5-year check-in to see if people have turned it around.
Representative Oakley?
Thank you, Madam Chair. So I do actually tend to agree that there should, that we can find a way for review instead of, I think, but what it would be is eliminating F5. But I will say I'd support that before I supported
We are
gumming
not
up the
on the bill
district,
draft.
the district courts. And to your point that you've asked about a couple times, Representative Zwanitzer, it does say for a fourth or subsequent conviction. So I think that might be related to your question.
All right, all those in favor of the motion say aye. We're going to try that one more time. All those in favor say aye together now.
Aye.
All those opposed say no. No. That motion has failed. All right. With that, committee, we'll move on to the second topic under bill drafts, contracts and restorative trade. Committee, if I can, on these topics is to remind you to go back maybe to your May meeting materials and to pull up the case related to these topics to remind you why we're here and the changes are being proposed. I think that will really help freshen our recollections. And of course, Mr. Fuller will remind us as well. So with that, Mr. Fuller?
Yep, Madam Chairman, 23 also 93, working draft 0.5, 1703. The meeting materials. The committee in May considered a case, Hassler versus Circle C Resources. And in that case, the Supreme Court overruled its previous adoption of the blue pencil rule, which is a rule that allowed courts to revise otherwise unenforceable or unreasonable non-compete agreements to make them reasonable and enforceable. Based on consideration of that case, the committee moved to bring back what previously was 2022 House Bill 38, a bill that this committee sponsored last year. That bill draft declared, and this draft does as well, declares that contractual provisions that restrain trade by preventing a person from engaging in a lawful trade, profession, or business after leaving employment, in other words, non-compete agreements, are generally void with specified exceptions. The staff comment on page 1 of the bill draft just notes that this draft is in substance basically identical to House Bill 38 from last year. There's been a couple of structural changes later on in the draft that do not change the substance. Page 2 are definitions. The staff comment on page 2 is replicated from last year's bill draft, and really I think the question there for the committee would be whether business entity by itself would be sufficient, whether that plain language term or whether a definition is desired or needed. The bill draft defines owner of a business entity to include, and business entity to include a sole proprietor or a partner in a partnership, included an LP or an LLP, and then any member of a limited liability company. Ownership interest tracks similarly. On page 4, line 1 is a definition of specialized training that refers to instruction or education that a person receives to develop the person's job skills in a particular field or expertise for a particular purpose. There's a definition of subsidiary, page 4, line 6. Page 4, line 17 is a definition of substantially all, which the committee settled on last year, meaning not less than 80%. And that's for purposes of a transfer of business interest. Page 4, line 20 is really the substance of the bill and provides that any provision in a contract by which a person is restrained from engaging in a lawful profession or trade is to that extent void, except as otherwise provided in this section. And then voiding a non-compete clause does not affect or render the remainder of the contract void. That's the language at the bottom of page 4 going on to the top of page 5. Page 5, line 4 are the exceptions to that general voiding language in subsection B. So subsection B doesn't apply to any provision where a person is selling the goodwill of a business entity or is disposing of all of the person's ownership interest in a business entity. Page 5, line 12 is any contract provision that prohibits employees from misappropriating an employer's trade secrets or other proprietary business information that generally isn't available or not readily available to the public. Line 17, contract provisions to the extent that they are applicable to executive personnel and officers of the business entity. That provision is based on Colorado law. Colorado law does not define that term and there's litigation kind of determining what executive personnel is, but generally it's fact specific and depends on the circumstances. And then page 5, line 21, the void language does not apply to any contract provision that requires an employee to reimburse an employer for the employer's actual expenses that are paid to third parties for specialized training within 2 years, if the employee separates within 2 years of receiving that training. The staff comment on page 6 just notes whether the language works for a competitor or is employed by a competitor is necessary in the bill draft. And then page 6, line 19, a contract agreement with an employer agreement can specify that the employer's actual cost of a hiring bonus, if the employee separates within 3 years, may be recovered by the employer. The staff comment on the bottom of page 6 just notes that the committee may wish to consider, and these staff comments are similar to last year's bill, whether some limit should be placed on the receipt of a hiring bonus. For example, a hiring bonus received due to a specialized skill for a position. Page 7, line 1, this is where the structural change is made, just to break this out into paragraphs. But it provides that upon mutual agreement and notwithstanding the general void language, any member of a partnership can agree not to carry on a similar business within a specified geographic area where that partnership's business has been. If another member of the partnership carries on a like business, if that person tries to carry on a like business or continues to carry on the business of the partnership. Paragraph 2, so page 7, line 15 is the same language that applies to a limited liability company. And then moving on to page 8, line 7, provides that any owner of a business entity who is selling the business entity may agree to refrain from carrying on a similar business within a specified geographic area. So long as the owner is selling all of the ownership interest or all of the business entity's operating assets. And then page 9, line 8 just specifies that this act that would otherwise void non-compete agreements applies only to contracts entered into on or after July 1st, 2023, which is the effective date. With that, I'll stand for questions.
Representative Yin.
Madam Chairman, thank you. Mr. Fuller, does this include or omit all of the standing committee amendments from the House Bill 38 when it was going through the House?
Mr. Fuller.
Yeah, Madam Chairman, I believe this does not include those.
Further questions for Mr. Fuller? All right, with that, I see Representative Stith is joining us online. Welcome, Representative Stith.
Madam
Anyone
Chairman.
else? Hold on just a second, Representative Stith. Do we have anyone else online? How many? Okay, just that one additional. Great. We'll bring her in next. We deal with all the people remote. Welcome, Representative Stith. Appreciate seeing you.
Madam Chairman, thank you very much. Appreciate the opportunity to make a real short presentation here. First, I couldn't help myself. There's a little bit of wordsmithing that I couldn't help myself from doing. I have a couple of comments. On page 5, line 8, right now it says all. I think since we have substantially all as a defined term, after the word all, page 5, line 8, you might want to add the phrase or substantially all, since we've got that as a concept already in the bill. And then on page 8, lines 17 and 18, as I read it, and I hadn't noticed this last year, but I think on page 8, line 17 and 18, it seems limited to selling your interest in a subsidiary, which is kind of strange. And so I think it might make more sense and more readable if we delete existing lines 17 and 18 and replaced it with selling all or substantially all of the ownership interest in the business entity or any subsidiary thereof. I think that would capture the intent there. The idea being that if someone's selling, all or 80% of what they own in it, then it's fair to make them sign a non-compete. Okay, thank you for indulging me in those two wordsmithing items. Big picture, I support this bill. I think it makes sense, especially in the light of the most recent blue pencil decision. I think employers may need a bill like this. So the question is, are there other exceptions or carve-outs that you might want to have? That's a difficult question. The purpose, I think, of this is to level the playing field between the employer and the employee. And this bill is especially useful when the employee does not have as much bargaining power as the employer does. However, you can think of situations where the employee or prospective employee does have significant bargaining power. And the primary example that I think the Hospital Association cares about are physicians, because you can imagine a physician who's being recruited from Houston, and they're going to pay him $400,000 or $500,000, or her $400,000 or $500,000. That person seems like they may have significant bargaining power and may not need the government's help in negotiating their contract. And so perhaps the physicians can fend for themselves. What makes that a bit problematic is that we have a class of physicians for whom the state of Wyoming has paid for their education in whole or in part, thinking of the WWAMI program or the WICHE program. And those medical students who graduate, they're in a different position because they're obligated to come work in Wyoming, right? And it's not great if they get to Wyoming and then they have to sign a non-compete. And if they get sideways with their employer, then they get booted out of their community, effectively have to leave their communities. That gets complicated. So it might be worth excluding physicians, but I think you may have an unintended consequence of having troubles with the fact that the state then has invested a lot of money, because the state essentially spends, I think, about $20 million a biennium on the WWAMI program, right? That's money the taxpayers have invested in these people. And we really want these people to come to Wyoming, and we don't want them to have an artificial reason to leave. However, on balance, maybe it does make sense to carve out physicians, maybe. I would be opposed to carving out other healthcare service providers. I think carving out physician assistants or nurse practitioners or nurses would go a little too far and be anti-competitive. Again, the purpose of this, of course, is we want our skilled workers, the people that we've spent taxpayer dollars training, at our community colleges to be welders or to engage in whatever profession. We want them to stay in Wyoming. We want them to stay in their communities. And this bill is one way to help those skilled laborers stay in our communities without the government having to spend any money. So those are my comments. Do you have any questions for me, Madam Chairman, or the committee?
Questions for Representative Stith? Representative Yen.
Madam Chairman, thank you. Representative Stith, you are aware of the amendments that we had made in the House Judiciary Committee. Would you be satisfied if we adopted those amendments in the interim committee.
Representative Stith?
Madam Chairman, Representative Yin, I do not have a present recollection of what happened last February. I apologize. I haven't reviewed those amendments. I would need to rethink each one of those, if as I recall, the bill died an ignominious death in the committee of the whole on a Friday afternoon late when we were all tired, if I recall. So I don't have there may have been some House committee amendments. I just don't have a present recollection, so I apologize.
All right, Mr. Fuller?
Yeah, Madam Chairman, I'll just run through this quickly. It inserted a definition of executive personnel for the bill draft, and that would mean a CEO, COO, CFO, or president. I believe it does make a couple of the changes Representative Stith mentioned in terms of adding reference to substantially all in a couple of different places. It limited the bonus, I believe, to the repayment of a bonus requirement if the bonus exceeded $5,000. And then I think it added, in addition to carrying on a business, owning, managing, operating, joining, or becoming an employee of another business, if you sold your assets of a business.
Madam Chairman, if I may,
Okay.
those amendments sound great to me now that I have a refreshed recollection. Thank you.
Great. Thank you, Representative Stith. All right, further questions to Representative Stith? All right, seeing none, let's go to Ms. Esch if we can online. Welcome, Ms. Esch.
Hi, thank you so much for having me, Madam Chair. So I also was there last year in front of the Joint Judiciary Committee, and I appreciate Representative Yin mentioning the amendments that were made.
Could you please introduce yourself to the committee and who you're with?
I apologize. Yes, thank you. My name is Amanda Esch. I'm a partner with Davis and Cannon in Cheyenne. I represent quite a few business owners, including one that appeared with me last year and is unable to be here today. But SNS Concrete and SNS Builders, based primarily out of Gillette and also here in Cheyenne and operating all over the state. So I'm here on their behalf, as well as many of the other business owners I represent that do utilize non-competes as part of their business management practices.
Thank you, Ms. Esch. Yeah, please continue.
Thank you for that reminder. So as I testified last year on behalf of those same business owners in front of the House Judiciary Committee, I don't think it's necessarily a bad idea, and my clients don't necessarily think it's a bad idea to have a bill put into law that clarifies the restrictions on non-competes. This current draft bill has the same problems that we had last year. Our primary concern is raised on behalf of employers that utilize non-competes as part of their business structure practice. And what I mean by that is a lot of businesses, it's fairly standard to ask current owners to sign non-competes, which seems to make sense to me practically, as well as oftentimes, as is the case with SNS Builders, the way that business is structured, they allow people to buy in and become shareholders, and sometimes substantially so. That's not anything that they force anyone to do. But in those instances, they allow them to become shareholders, but they have to agree to certain non-competes, including so long as they hold those shares. And at times, depending on the number of shares that they're allowed to buy, if they choose to leave the company or their employment is terminated, they'll still remain a shareholder and retain that benefit and have access to information. And in those cases, we would argue very much that non-competes are still very much appropriate and fair, to Mr. Stith's point, given the nature of the bargaining position of the powers that may be in those cases. So we would certainly advocate for the amendments that were made to the bill last session by the House Judiciary Committee. We think those are more than appropriate. So that's the position I'm bringing here today, and I'd be happy to entertain any questions.
Ms. Esch, thank you so much. Questions for Ms. Esch? All right, thank you. Representative Oakley and I say hello. We're all in school together. Great to see you, Ms. Esch. All right. Further public comment? Mr. Boley, please come forward.
Madam Chairman, committee members, Eric Boley, President of the Wyoming Hospital Association. It's not very often that I'm the shortest guy sitting at the table. You want to introduce yourself?
Yes, I'm Brad Cave. I'm following the heart on behalf of the Wyoming Hospital Association.
Great to have you both.
Madam Chairman, if Representative Washut just wants to table this, make a motion and table it, we'd be happy with that, and we can get caught up on time.
You can just clean the slate of the work of the Judiciary Committee in short order. All right. This will be tough on committee, so we got to kind of work it. It might be tough like the last one where we got to get the details through. So, all right, good to see you. Please
You too,
proceed.
thank you. So, Madam Chairman, we obviously we have some concerns with this, and they're very similar to the ones that we talked about last year. We did meet with Representative Stith in Sweetwater County a couple of weeks ago. We had two of the hospital CEOs, Representative Stith was there, and then also the board chairman for Sweetwater County Memorial Hospital. And we did talk about potential compromise or carve-outs, but in speaking with Mr. Cave, we're not convinced that this legislation is even necessary, and I think that that's where we'd like to start. I circulated a white paper that y'all have that Brad put together regarding the Supreme Court's decision, and I think we would like to start there and run through that, and I'll turn it over to Brad if that's okay with you.
Sure, yeah. Mr. Cave?
Madam Chair, thank you. I'd like to begin. There you go. Thank you very much. I'd like to begin by thanking the committee for the opportunity to speak in opposition to this bill. As Mr. Boley said, the bill at this stage of the development of law in Wyoming is really unnecessary. Mr. Fuller referenced the Hassler opinion, which was a key opinion that came out at the end of February of this year. But there have been 4 opinions since July of last year where the Wyoming Supreme Court have overturned the enforcement of covenants not to compete against employees. 3 of those opinions, or I should say 2 of those opinions, the court reversed preliminary injunctions against employees. One of those opinions, the court threw out an arbitration panel award in favor of an employer against an employee. And then the Hassler case, where the court essentially said that the rule, the blue pencil rule that had been in place for 30 years was no longer part of Wyoming law. We have an entire sea change in the environment for the enforcement of covenants not to compete in Wyoming since July of last year. The Hassler case was the most significant of those cases. For many years, and I've drafted lots of covenants not to compete. I've represented both sides in court on covenant not to compete cases over the years. I can tell you that blue pencil rule was a cornerstone of covenant not to compete law in Wyoming, and the Wyoming Supreme Court essentially said it doesn't apply anymore. What does that mean from a practical perspective when it comes to an employer's ability to protect things like trade secrets? Now the employer has to draft a covenant not to compete. They take on the risk that if they ask for 8 months and a judge says only 6 months is reasonable, the entire covenant is unenforceable. If they ask for 3 counties to restrict the employee from competing in 3 counties, and the judge says, no, it's only reasonable in 2 counties, the entire covenant is not enforceable. And the employee then goes on their way and competes in the head-to-head in the counties where the employer does business. So that's a huge change. For the Wyoming Hospital Association, what that would mean is a physician who's recruited by a hospital, they pay the relocation expenses, they pay the signing bonus, they pay a substantial salary, they come into the community, and the non-compete maybe is a year, and for the county in which the hospital does business, which is not an uncommon term in healthcare covenants not to compete. And a trial judge could decide, well, you know, I think for this particular specialty, that non-compete should have only been 6 months. And because the non-compete was a year, I'm throwing the whole thing out. So that's the law today in Wyoming. A trial judge could do that today in Wyoming. So this bill says, well, you can't have those non-competes at all. What I'm telling you is the landscape in Wyoming makes this bill unnecessary, because now employers are required to very carefully define the duration and the geographic scope of their non-competes. The other principle that the Wyoming Supreme Court incorporated in these rulings, these 4 opinions over the last 14 months, is the Wyoming Supreme Court said, not only do you have to narrowly draft the duration and scope, but the employer has to come to court and prove that they have a business interest that supports the enforcement of non-compete. I can't just do a non-compete to prevent competition. I can't just have a non-compete because I don't want my employees to go down the street and work for the other guy. I have to have a business interest, a special business interest. So that means I have to prove that I have given trade secret information to the employee. I have a secret that my competitor could benefit from, and I've told that employee that secret, and they use it in the performance of their duties. I have to prove that I've given the employee, as the employer, I've given the employee the opportunity to develop special relationships with my customers. So that's a perfect example in the healthcare setting. Who more than your doctor has a special relationship with you? That's exactly the kind of relationship that a non-compete can protect. You think about insurance sales. An insurance salesman agent knows a lot about a customer and their business interests and their private and confidential information about assets and things like that. That's the kind of special relationship that a non-compete is entitled to protect. A third kind of thing might be an innovative technology. If I'm in a technological field, I've developed a very unique software or an algorithm or a formula for an additive for some oil and gas application, and the employee knows all about that. I have to come in and prove that sort of thing, though. I can't just say it exists as an employer. I have to come in and prove to the judge now. I've always had to, but these recent Supreme Court cases have made it very clear that trial judges need to hold employers' feet to the fire on proving that they have that protectable interest and that the employee has received it. So the employer has to do that. In these cases, 2 of these cases, the employer got sent home with a loss because they failed to prove that actual special business interest supported the covenant not to compete. The third and fourth important aspects of these cases is that the court, in one of the cases, the court chastised the trial judge because the trial judge didn't let the employee present evidence about how the covenant was against the public interest. So every time you try to enforce one of these, the employee gets to come into court and say, this should not be enforced because the public interest is in favor of me competing in this industry, in this area, against my former employer. And they get to put on evidence about the public interest, and they get to argue to the judge. In one case, one of these 4 cases, the judge didn't let the employees do that. And it was a case involving nurses who provided home health services. It was Representative Stith's case, actually. So the trial judge erred in that way, and the Supreme Court reversed that decision. And then finally, the court reinforced that in that same case, that if I try to impose as an employer, if I try to impose a covenant on an employee after they're already working for me, I have to pay them for it. I have to give them something new for that covenant not to compete. I can't just come in someday to the break room and say, hey, starting tomorrow, we all now have covenants not to compete, sign here. Those would be unenforceable and invalid because I have to pay for that restriction. And that's been the law, but the court made it very clear again in the case that Representative Stith represented the plaintiffs in. The court made it very clear that that has to be a bargain for exchange. You have to go to the employee and say, hey, I want you to sign this covenant not to compete, and I'm willing to give you this much an additional benefit or money for that covenant. You can't just sort of make it up as you go along. You have to make a bargain for exchange. So everything's changed on covenants not to compete in the last 14 months. If we adopt a bill that essentially says they're no longer valid except for particular industries, we're essentially telling the legal community as well as the employer community that there is no real reason to even try to protect our trade secrets in Wyoming anymore. If you're going to give an employee a trade secret, if you're going to introduce them to a client and provide that client's confidential information to the employee. If you're going to show the employee a secret to how you do business and make money, you do that at your own risk, because that employee will be able to essentially say, I'm going to go down the street to the competitor, I'm going to work, I'm going to make more money, and I just dare you to try to enforce that against me. They already have that upper hand now. This bill will just make it even more difficult to protect those things. It'll make it more difficult for hospitals to obtain the return on that investment that they make in every provider that they hire. And so we stand in opposition to this bill, and I'm happy to take questions, Madam Chairman.
Thank you, Mr. Cave. Appreciate that really great summation of the recent activity of the Supreme Court and how important I think this issue is to Wyoming. And of course, those cases that you referenced only refer to those cases in the Wyoming courts and not the federal courts per se. And there's a whole other body of law happening in our federal courts as well here in this district, in the Wyoming district. One piece that I have a question for you on, Mr. Cave, and want to ask you to explore is the distinction between the concepts between a trade secret, between a client or a customer list, and a covenant not to compete, because those are not the same things. And so can you help the committee understand and distinguish those different types of concepts?
Madam Chairman, I'll do my best. So starting with the last one, a covenant not to compete essentially says that the employee cannot engage in a competitive business within the geographic scope defined by the contract and for the period of time defined by the contract. A related kind of covenant is a covenant not to solicit, which is limited to the employer's customers. And it says that the former employee cannot solicit those customers to do business also within a geographic scope and a time period. Trade secrets are defined under Wyoming law, and there's a well-developed body of law that tells us what trade secrets are, but it's a very broad definition, and essentially it's any sort of business process, formula, secret sauce, anything that the business uses that is valuable to the business because it's not widely known to competitors. And if competitors knew it, they could make money on it, and they could take away the business of the company that developed it. So that's a really thumbnail sketch of a trade secret. There's also confidential information that may not qualify as a trade secret. You mentioned customer lists. Some information on a customer list may not be confidential. If I'm in the restaurant supply business, there's no confidentiality in the identity of restaurants. There may be confidentiality in the terms of my deal with a particular restaurant. So the customer list by itself, just the identities, may never have protection, but the more data that is on that customer list, the more information that the employer develops related to the customers, the more potential that list and the associated data becomes a confidential information that ought to be subject to protection. I'm not sure if I've answered the chairman's question.
It does. Thank you, Mr. Cave. Thank you. I think it's just important for the committee to understand that perhaps a covenant not to compete doesn't necessarily mean a non-solicitation prohibition or a trade secret prohibition, and that those are different concepts which merit their own policy considerations. Yes. Further questions from the committee of Mr. Cave? Mr. Boley?
Madam Chair, if I may, if you remember last year, we kind of got sucked into this one. We weren't even aware that this bill was being introduced, and we were in your committee meeting for another topic when this was introduced. I am concerned that the hospital association's kind of out in front of this. We're only one interested party, but I think others are interested in this. One of the things that I'm aware of is that many people didn't even know this was being considered because of how it was titled on the agenda on the LSO website. It doesn't talk about non-competes where it was posted out. It goes with the title of the bill. But this is important to other industries, not just ours. The other thing is I would just reject the notion of this being prohibitive to WWAMI students. I actually serve on the WWAMI Advisory Council. I've spoken with the head of the WWAMI program. We're not aware of anyone that has left the state because of a non-compete or because they didn't want to sign a non-compete. We start recruiting those students the first year they're in their rotations and in the school, and do all we can to bring them here and to build that up, build their practice up. There's a substantial investment that's made, and we talked about this last year in bringing these providers on. It's not just physicians, it's physicians assistants, it's nurse practitioners, CRNAs. There's a whole list of them that I think Representative Stith said he only felt like physicians should be, but the amount of investment that we're making in some of these subspecialties, even if they are mid-level providers, are substantial. And it can take up to 3 years to even start to see a return on investment in some of these. So this is a really important thing for us. And it's true, 3 years. We also spend a great deal of time trying to keep the cost of healthcare down. But when we start seeing some of these subspecialties move and set up businesses in competition right down the street, all it does is drive up the cost of healthcare, because many, many times the highly insured are taken to those subspecialty surgery centers or wherever they might be, and then the governmental payers are left with the safety net hospitals, and it doesn't decrease the cost of healthcare, it actually increases it. There's a whole lot we could talk about on healthcare, but this is a big, broad topic, not just specific to healthcare, but obviously we're here in front of you on this. Thank you.
Yeah, thank you so much. All right, questions? Representative Rodriguez-Williams.
Thank you, Madam Chair. A question for Mr. Boley. I have a note from last session that you had mentioned that the Biden administration had issued an executive order stating that they wanted to ban or limit non-compete agreements specifically for physicians. Just wondering if anything came to fruition on that a year later.
Yeah, Mr. Boley.
Madam Chairman, Representative Rodriguez-Williams, I am not aware of anything actually happening after that was issued. Are you?
Madam Chair, vaguely, Representative Williams, I think the Biden administration did adopt an executive order relating to federal contractors and the use of non-competes by federal contractors, but I'm not familiar with the scope of that order.
Is it fair to say that because you are not familiar with it, it's likely that that's not affecting Wyoming hospitals and physicians there? Is that probably why?
Madam Chairman, I think that's a fair.
Or you would know, right?
Yes.
All right. Further questions from the committee? Representative Yen?
Madam Chairman, Mr. Cave, thank you. So some of, I think, your testimony indicated that the reason that we shouldn't pass the bill is because judges are already determining the parameters of what should and should not be a lawful non-compete. Is that a good summation of part of that argument?
Madam Chairman.
Mr. Cave?
Representative Yen, under the new case law, judges have new guidance about how to determine that, yes.
Thank you, Madam Chairman.
Further questions of Mr. Cave? Mr. Boley? All right, seeing none, thank you both. All right, further public comment on this bill? All right, Ms. Bush.
So much more time in front of Judiciary than I've ever spent. Members of the committee, Sheila Bush from Wyoming Medical Society. So I'll start by saying the Medical Society historically has remained neutral on this bill. I think it's suffice to say that we have a very divided membership. You have some physicians who are employed within hospitals and have very strong feelings about their inability to move within a community. They believe that non-compete clauses, specifically the covenants not to compete, take away any incentive of their employer to create positive work environments if they're locked in and can't leave. It's particularly true for specialists and subspecialists. Patient volume dictates they can only work in 2 to 3 communities in Wyoming that have the population that can support a specialist. And so if that relationship sours between a physician and their employer, they are left without option other than leaving the state. And that's often not what they want to do. This is the large reason WWAMI comes up in this conversation. If that relationship isn't a positive one within the 3 years, they don't have an option. They're just stuck in a really bad situation sometimes. I will say our physicians who are independent and remain in private practice often use these same agreements because of their investment in exactly the things that the Hospital Association mentioned. So if they're training a PA, an MA, a nurse, any of those other providers that are critical to their ability to practice, especially with the new laws around PA optimal team practice that we passed just this past year or 2 years ago. Physicians having those PAs in their practice and then not having any option but to have those PAs take the knowledge that they gain, the training, and the patients down the street to then compete is tricky, which is why we've remained neutral. I am testifying because physicians were called out in such a specific way. I think it's really important that you understand how nuanced the issue is. It's very complex. As soon as you start carving out physicians, regardless of your action on the bill, when you start carving out one profession, I think it begs trouble, and that's all I would offer.
All right, seeing none. All right, further public comment on this bill? Anyone else online? All right, committee, back to you. Public comment is closed, but we might bring you back.
Move the bill.
All right, moved by Representative Yen, seconded by Senator Kolb. Amendments, discussion, Representative Yen.
Madam Chair, I'd like to move the amendments that the Judiciary House Standing Committee made for House Bill 38 with the line numbers reflecting what the new draft line numbers are.
I think that's clear. Moved by Representative Yen, seconded by Kolb. Further discussion on that motion. Committee, you all have a chance to see those. Those are online, posted on the different engrossed versions of the bill from this last session. Further discussion? Seeing none, all those in favor say aye. Aye. All those opposed say no. That motion has passed. Further amendments on the bill? Question being called quietly in my ear by Senator Cost. Roll call vote on the bill.
Senator Cooper?
Aye.
Senator French excused. Senator Kolb?
Aye.
Senator Cost?
No.
Representative Prego?
No.
Representative Larson?
Aye.
Representative Oakley?
Aye.
Representative Provenza?
Aye.
Representative Washit?
No.
Representative Rodriguez Williams?
No.
Representative Yin?
Aye.
Representative Zwanitzer?
No.
Co-Chairman Olson?
Excused.
Chairman Nethercott?
No.
That does not pass.
I don't know. What's the final vote?
Madam Chairman, I have 5 ayes, 7 noes. In the Senate, 1 aye, 3 noes. In the House, 4 ayes, 4 noes.
Great. Committee, just so you know, and to the lawyers, I think, paying attention across the state, as Mr. Boley had identified, this issue came to us both from Representative Stith and then as a part of our regular review of Supreme Court opinions. And I think that that reflects the continuing concern across Wyoming about these covenants not to compete. And I have always supported our obligation to continue that conversation here as members of the legislature who guide policy and might be able to reduce some of the litigation that is currently happening amongst our employers and employees and businesses and entrepreneurs who want to provide competitive environments within our communities, and very complex policy considerations for us to consider. I do think it is important for the state and all of its stakeholders, from physicians to construction companies, employers, employees, and business opportunities, and just community members, to continue this conversation. I do believe it will continue to be litigated in the courts, even though the court has continued to provide further guidance and clarity on the topic. And so I want to just keep this on the forefront of your attention, recognizing that there might need to be a legislative solution to provide some certainty because certainly the frequency of the litigation we're seeing indicates that need for more certainty in our business environment for employers and employees and other entrepreneurs. But I don't think we're there yet, and nor should we be. I really think the conversation is very, very complex and requires years of effort by the legislature to get it right. So it's okay to vote no now and vote later, because sometimes good legislation takes work. All right, with that, we will move on to LSO Bill Draft 94, Juvenile Courts Concurrent Jurisdiction Clarification. Mr. Fuller?
Yep, Madam Chairman, members of the committee. In May, the committee considered Rosen versus State, where the Supreme Court considered the question of whether concurrent jurisdiction that the Juvenile Justice Act confers upon the juvenile court depends on an offender's age at the time of the offense or the offender's age when charged. The court held that concurrent jurisdiction depends on an offender's age at the time of the offense, regardless of when that offender is charged. After discussion, the committee moved for this bill draft to essentially codify that holding. So this bill draft just simply clarifies that the juvenile court has concurrent jurisdiction, meaning that depending on the requirements of the Juvenile Justice Act, the person may be charged in, the case may be brought to juvenile court or district court, but that the juvenile court has concurrent jurisdiction over persons who are 18 and older, but who are alleged to have committed offenses or delinquent acts as minors. And so on page 2, lines 8 through 10 of the bill, this is the only change to 14.6203C to say that the juvenile court has concurrent jurisdiction in all cases other than status offenses in which an adult is alleged to have committed a criminal offense or to have violated a municipal ordinance while the adult was a minor. The staff comment just notes that in light of this change to codify that holding, the committee may wish to consider whether 14.6231C2, which is produced below, should be amended. And what that paragraph says is that all orders under the Juvenile Justice Act terminate with respect to a child adjudicated delinquent when the person reaches age 21. And I think the question there really would be, if all orders terminate when someone is 21, I think the operation of the bill draft would be that a person could be charged as an adult up to age 21. Similarly, 14.6247 just notes that if a child is placed on probation, probation is discharged on that person's 21st birthday. With that, Madam Chairman, I'll stand for questions.
Thank you, Mr. Fuller. Questions of Mr. Fuller? Committee, I just want to remind you, it's getting late. This bill seems simple. It's possible we'll go down a rabbit hole and get frustrated and complex and take rash action. So slow her down and also go back to the May meeting materials and look at that opinion for further clarification as to why we're here and what we're doing. And with that, I think I'll call up Director Schmidt of the Department of Family Services to discuss this bill draft.
Thank you, Madam Chairwoman Corin Schmidt, Director of the Department of Family Services. I think the bill in and of itself just kind of codifies the decision. The only place that I would maybe express some concern is in the staff notes and discussion around changing the 21-year-old threshold to 1, I don't know what, but 2, keeping it at 21 makes it easier for us to serve the population that we're charged to serve. So I do not think that there are going to be a lot of situations where we're going to end up with, some sort of question about what to do if a child is an adult, but then charged as a minor because the offense was committed as a minor. I do not think we're going to see a lot of those, so I don't think this is going to be a big problem. But removing that 21-year-old status starts to affect our whole system.
Director Schmidt, I think the committee, or staff comment is that an order would automatically terminate when the juvenile reaches the age of 21. Do you think that's a problem?
Madam Chairwoman, that's what happens now. Removing that date, removing that age would be, I think, a problem.
Do you have a copy of the bill draft?
I do.
Okay. Stay close. Questions from the committee? Mr. Fuller, did you hear Director Schmidt's concerns? Do you share those concerns?
Madam Chairman, I'm agnostic on whether that's concerning or not. I think the reason I brought those up is that, you know, the language in the bill draft, while it codifies the holding, isn't clear. You know, it's unclear whether a person who, say, is age 22 could be charged under this new language. Some states, you know, for example, I believe it's Montana, clearly says that it would be a person under 21 may be charged. So that was my only intent in raising those two issues, not that the age in those sections needed to be changed, but rather should that age 21 limitation be added to the new language in the bill draft.
Okay. Thank you, Mr. Fuller. Any comments from the committee? Questions for the director? All right, seeing none, thank you. All right, further public comment on this bill? Seeing none, public comment is closed. Committee, back to you. Moved by Senator Kolb. Is there a second? Seconded by Zwanitzer. Discussion on the bill. Does anyone know what's happening? Roll call vote on the bill.
Senator Cooper. Aye. Senator French excused. Senator Kolb.
Aye.
Senator Kopp.
Aye.
Representative Crago.
Aye.
Representative Larson.
Aye.
Representative Oakley.
Aye.
Representative Provenza.
Aye.
Representative Washut.
Aye.
Representative Rodriguez Williams.
Aye.
Representative Yin.
Aye.
Representative Zwanitzer.
Aye.
Co-Chairman Olson excused. Chairman Nethercott.
Aye.
That passes.
All right, committee, with that, we'll go on to our last bill draft for the day, Working Draft 97, version 4, District Attorney's Bar Licensure Requirement. Mr. Fuller?
Yep, Madam Chairman, this bill draft was one the committee requested, not directly related to a court opinion, but simply goes into 91802B. Current language says that each district attorney shall have been licensed attorney for at least 4 years and a member of good standing of the bar immediately prior to his election. This just adds a sentence that states that the district attorney must be a licensed member in good standing with the bar throughout the term of office for which the district attorney was elected or appointed.
And Mr. Fuller, in Wyoming law, the reference to the district attorney, does that include a county attorney as well?
Madam Chairman, it does. You know, I would note that this statute, though, does deal specifically with district attorneys.
Mr. Fuller, could you find the statutory section for county attorneys elected qualified? It would be a matching statute. Representative Oakley?
Thank you, Madam Chair. I'll look too, but I do believe that it's defined and it includes county attorneys.
Yeah, it is. Further questions from the committee? Give Mr. Fuller a minute here. We're just holding to make sure, certainly the application should apply to an elected county attorney as equally as to an elected district attorney. Just making sure we're encompassing that and the bill addresses both of those concerns. I think it does, but let's just make sure.
So, Madam Chairman, I will clarify that. Generally speaking, and this is 81102A10, district attorney includes a county and prosecuting attorney in the county where the office of district attorney has not been created. This definition, though, does not shall specifically not apply to 91801 through 91811. So this section, that definition does not apply here. So this section only concerns district attorneys.
All right, so I need a motion to include elected county attorneys. That's moved by Senator Cole, but seconded by Representative
And
Washit. Mr.
Madam
Fuller?
Chairman, I apologize. I didn't catch a motion for the bill.
Oh, thank you. Thank you. You're correct. Representative Provenza has moved the bill. Is there a second? Seconded by Larson. Senator Kolb has made a motion. Discussion on that at all? I'm sorry, what's happening? Public comment? Great. Anyone else? How am I doing? Should we take a break? Okay. Any amendments on the bill? Senator Kolb?
I'd wish to make an amendment to include county attorneys as with the same provisions as the district attorneys would have.
Seconded by Representative Washit. All those in favor? Is there a discussion?
Madam Chairman,
Representative Yen?
so maybe it's the same question that Brian has. Is the motion for all of the requirements that district attorneys have, or just the specific one that we're adding for district attorneys?
Madam Chairman, I think I can address this. 183301A says that in judicial districts where the district attorney has not been created, there's elected a county and prosecuting attorney, quote, who at the time of his nomination and election and during his term of office shall be a member of the bar of the state. So that is currently, that's existing law.
Motion withdrawn.
Read it again.
Yep. So there shall be elected in each county a county and prosecuting attorney who at the time of his nomination and election and during his term of office shall be a member of the bar of the state.
In good standing?
Those words are not here, Madam Chairman.
We need to amend that.
Do you want that amendment, Madam Chairman, then?
Pause.
I would so move to in 18, or whatever section Mr. Fuller referenced, to add good standing to that section.
All right, so procedurally, Senator Kolb's going to withdraw his motion. Representative Zwanitzer, his motion is to add the term good standing to the statutory reference of Title 18.
And Madam Chairman, I would assume that would include any other conforming changes to the bill title.
Correct. And there's a second on that amendment from Representative Larson. All those in favor say aye. Aye. Any opposed, say no. That motion has passed. Committee, any further amendments on this bill draft? All right, do we want to see this again at our next meeting? Roll call vote on the bill.
Senator Cooper?
Aye.
Senator French excused. Senator Kolb?
Aye.
Senator Cost?
Aye.
Representative Crago? Aye. Representative Larson?
Aye.
Representative Oakley?
Aye.
Representative Provenza?
Aye.
Representative Washit?
Aye.
Representative Rodriguez Williams?
Aye.
Representative Yin?
Aye.
Representative Zwanitzer?
Aye.
Co-Chairman Olson excused. Chairman Nethercott?
Aye.
That passes.
All right, committee, good work. Before we end and pack up, we're going to go through with LSO staff. It's 4:47, on time, under budget. And go through our outstanding items that we've done for the last couple of days, remind us what we're doing and where we're going for our next meeting.
Yep. And so, Madam Chairman, would you want a recap of the bills the committee has voted to sponsor as well in that?
I think that'd be helpful.
Okay, I'll just run right in order then. Madam Chairman, members of the committee voted to sponsor 23 LSO 94 State Park Rangers retirement, 23 LSO 90 child support amount. For 23 LSO 2, which was the probate fee amendment, the committee is moving that to November with a working group of Ms. Butler, Representative Washit, and the clerks of district court. The committee voted to sponsor 23 LSO 96 treatment courts to the judicial branch. The committee failed to sponsor 23 LSO 114, which was a child endangering bill. The committee sponsored 23 LSO 89, the Office of Guardian Ad Litem program references. The committee moved to November the Clerk of District Court bond amount, 23 LSO 92. Committee voted to sponsor 23 LSO 194, Judges Housing Allowance. Committee failed to sponsor 23 LSO 113, homicide by vehicle in a school zone or crosswalks. The committee requested a bill draft to appropriate $10 million for purposes of pedestrian bridges and crosswalks in school zones and similar areas. The committee voted to sponsor 23 LSO 109, the data trespass repeal, and 23 LSO 111, defining aircraft for game and fish purposes. The committee moved 23 LSO 108, the prohibiting travel through land for hunting purposes, to November. The committee voted to sponsor 23 LSO 110 concerning drones and penal institutions, and 23 LSO 112, trespass by small unmanned aircraft. The committee failed to sponsor 23 LSO 88, assault and battery for healthcare workers, and failed to sponsor 23 LSO 93, contracts and restraint of trade. The committee requested a bill draft to draft 2022 Senate File 76 with the amendments discussed. The committee indefinitely tabled 23 LSO 95, the interlock device bill draft. The committee voted to sponsor 23 LSO 94, juvenile courts concurrent jurisdiction clarification, and voted to sponsor with amendments 23 LSO 97, district attorney's bar licensure requirement.
Mr. Fuller, thank you. Excellent recap. Any questions or comments from the committee? Just a reminder, it's indefinite, when you move to table a bill, it's indefinitely postponed and the committee does not review that bill again. It's a pretty desperate move, or pretty aggressive move. Not desperate, but aggressive move when that happens. And just so you know, we will not be hearing that issue again at our next meeting. With that committee, great work. Appreciate, we worked a lot of heavy bills. Co-Chairman Olson did a great job yesterday. Had a really long day. And the same again today. I wish you safe travels home. It was great to see you again, and we'll see you November 10th and 11th in Cheyenne at the Historic Supreme Court Chamber. Mr. Fuller?
Madam Chairman, one more thing. For those members who have not turned in their reimbursement forms, if they would bring them to you for signature and initialing.
Thank you, Mr. Fuller. Thank you, everyone. Meeting adjourned. Oh, wonderful.